The Honorable, the Supreme Court.
Good afternoon, everybody. Thank you very much. Please be seated. Let's call the case.
Good afternoon, Your Honors. The matter before the court this morning is the case entitled Jane Doe versus Victoria Camacho. Case number 23-AP-325. Representing the appellant, Jane Doe, is attorney James A. Valenti. Seated at counsel table with attorney Valenti is attorney Zach Hozid and Christopher Janusis. Representing the appellee, Victoria Camacho, is attorney Kevin Lumpkin.
Before we start, is the audio on?
It is not.
Yeah?
Should be on now, Chief. Sorry.
Uh-huh.
You should be good now.
It could be what?
It's on now.
Yeah, now it's on.
Okay. Oh, there it is. Thanks. I want to make sure I hear what you all say, you know, that I'm a little bit foggy in the ears. So counsel, come on up. Foggy in the ears is a medical diagnosis.
One which many of us have, Chief.
Yeah. Counsel, please, for the record, introduce yourself and identify your client.
Chief Justice,
When you're ready. I'm not trying to rush you.
thank you very much. Chief Justice and members of the court, may it please the court. My name is James Valenti. I represent the appellant, who is Jane Doe, for the purpose of this action. May I proceed?
Yes, please. Thanks very much. Thank you.
This is a case in which the court is asked to analyze 12 VSA 558. 12 VSA 558 has been on the books since 1972, but it represents common law that can be traced back as long as Vermont has existed as a state, and indeed before it was founded. The first case that analyzed the language that we're here to address today was Spear versus Curtis. That was in 1867. And the line of case law finding that Section 558 should be liberally construed has continued with relatively little interruption through Hayden versus Caledonia National Bank, which was a 1942 case. Analyzed.
Mr. Valenti, 558 requires certain requirements. It's got a time limit, 1 year, and it's got factual determinations involving excusable neglect and a reason why it should be applied. And how does that work in this case?
Well, in this,
Apply with the 1 year. I'll give you the 1 year, but on the specific findings regarding the
on a specific, I'm sorry, I didn't mean to interrupt.
No, you're sorry.
Here, the issue is that the first attempt, the completion of service was something that was accomplished with the assistance of a private investigator within a deadline set by the court. The private investigator filled out an affidavit in which they described circumstances that would have satisfied the statutory requirements for service in New Hampshire. And it was only after moving for default judgment, in moving to dismiss, by the way, after the time to answer the complaint had passed, that the appellee raised the issue of incomplete service and argued that because she didn't live with her mother, which was contrary to what her mother had represented to the process server, there had been no service. Our position is that under 558, to answer your question, that was either an inexcusable mistake by the plaintiff, who had an affidavit evidencing service from the process server, or it was a mistake by the process server, who could have been more diligent in trying to serve the then defendant, now appellee, rather than effecting service upon the defendant appellee's mother.
At the place of her abode.
At her home, and where she told the process server the defendant at the time lived, which was testimony that the court credited in its hearing on the first motion to dismiss. It's notable that the first appearance by the then defendant Camacho in this case came the same day that then plaintiff filed a motion to a motion for default judgment, because that showed that actual notice had been achieved sometime earlier, that the defendant, I'm sorry. It looks like you want to ask me a
No,
question. I just want to be sure.
I'll interrupt you. I don't have a problem doing
Okay.
that.
It shows that the defendant had hired counsel and that that motion to dismiss was prepared. It wasn't filed within the time to answer. And there is case law in the books, the case line runs Myers, Christensen through Messier, that actually says that the defense of defective service is arguably waived. One of those cases, I believe it's Christensen, is actually a case where the same issue came up. The reason for defective service alleged was that it was upon an improper agent. There it was the former president of the company served.
And I am going to interrupt you.
Please, please.
Okay. Is it your position that insufficiency of process as described in 558A1 is the same as insufficient service of process?
Yes, and there are two reasons that this is the way the court should read the statute. One, it's a remedial statute and should be construed liberally. So if the legislature wanted to say that this is what we mean by service and this is what we mean by process, and in one of these situations, there should be no remedial measure, it should have stated that specifically. But
if I'm sorry, are you finished?
well, there's just a quick second point, which is that it doesn't make much sense that you could say that one of the grounds would be unavoidable accident by the plaintiff, and then the other pair of grounds would be default or neglect by the process server, if the only thing that the statute was meant to address was how the process was drafted.
Now I'll interrupt.
Please.
It's been a while since I've looked at it, but don't the rules that set forth affirmative defenses list both insufficient process and insufficient service of process?
Yes, those are listed, I think, sequentially in Rule 12. You're absolutely right about that.
So doesn't that suggest that they are two different things?
It does, but the problem is there's no case law on the books, despite the fact that this one-year extension has existed for a very, very long time, making that argument and having it even rejected, much less having it endorsed by the Vermont Supreme Court. And the one thing that is consistent as you follow the case law from the very first cases in the 1800s, Spear, all the way through Leo versus Hillman, is the Supreme Court has repeatedly said that it's not reasonable to engraft upon the statute exceptions. If the court ruled that service and process are two different things because that's the way they're used in Rule 12, even though as far as I can tell, there's no functional difference between the two, in the sense that in Rule 12, they're just listed as a number of defenses. And for what it's worth, I think that that's something that we see in some other states in Rule 12, where, for example, they list a non-exclusive group of affirmative defenses that often includes pretty archaic affirmative defenses that seem somewhat thrown in and not placed there because it's meant to be the Civil Rules Committee saying we are now going to say exactly what all the affirmative defenses are. Our view is that the distinction you cite in Rule 12, while technically correct, it's not the kind of thing where the Rules Committee would have been looking at that and saying, well, how is this going to affect the statute of limitations? And moreover, there's a question of whether a procedural amendment to the rules could affect the statute if the statute itself didn't say, we, the legislature, want to distinguish between these two different things.
558 only applies to one of the two, insufficiency of process.
Well, I think that is, it's the language of 558A1, but the problem with that is that the second portion of that sentence says that it could be insufficiency of process caused by unavoidable accident or by default or neglect of the officer to whom the process was committed. And so if the request by the appellee is that this court only consider errors of process to be essentially draftsmanship or getting the process to the server, the second portion of that sentence would make no sense. How could default or neglect of the officer to whom the process was committed be grounds if what the drafters of the statute meant only related to things that a process server cannot control.
But insufficiency of service of process doesn't appear anywhere in 558, correct?
No, but you can also reasonably read 558 to read insufficiency of the process caused by unavoidable accident. For example, let's say I caption the summons in the wrong court. Clearly, that's an example, I think, of I'll call it the conservative reading of that definition. But it says that, and then it says, or default or neglect of the officer to whom the process was committed. And so you can reasonably read that statute to say it could be insufficiency of process caused by unavoidable accident. You file in the wrong court, you file in the wrong venue, or default or neglect of the officer to whom the correct process was committed.
And so if 558 does apply to service of process, what is the default or neglect here?
I'm sorry, what is the
default or neglect here?
The default is based on the fact that it's like paying a loan. If you don't pay your loan, you default on it. A process server has one job. They need to serve the process, or else the lawsuit cannot exist, or it cannot continue to exist beyond a very gestational phase. And so here, it's clear that the process server relied on information that was incorrect. The motivations, the intent, all of that is subject to some argument. But nobody has accused the officer who attempted to serve process of doing anything wrong or making any unreasonable mistakes. But the fact of the matter is, if he had served the defendant directly, we wouldn't be here.
See, I'm sorry.
No, Chief, please.
Let me, but you want a remand, am I right? Do I see that in your papers?
Yes,
And what's the remand?
the remand would be so that
Yeah, there's a disputed question of fact you want resolved?
well, I think, Your Honor, we're asking for reversal or remand.
Or
Correct.
not and, or.
Right, because there is a secondary argument here that this was simply a premature ruling because all that was filed was the complaint, and the basis for the ruling was really the first dismissal decision by the same court.
But aren't you
Justice
saying-
Oh,
Go ahead.
Thank you. Thank you, Justice Eden. Mr. Valenti, I just want to actually ask this question regarding what you talked about as to the facts. Wasn't there a finding below by the trial court that mom was not, or Ms. Camacho's mother was not an agent of Ms. Camacho's, and that she had called whoever was representing, and I think it's you, your office to say that Ms. Camacho no longer lives with her?
Good.
So doesn't that make the service deadline within your control, as well as issues regarding service that were brought to your attention before the deadline passed?
No, for two reasons. One is that the service was effected upon Ms. Wright, who is Ms. Camacho's mother, on January 17th. The deadline at that point set by the court was January 20th. Even accepting Ms. Camacho's testimony, Ms. Wright's testimony, Ms. Camacho's mother's testimony as credible, she says she made the call a week later. That would have been after the deadline for service had passed. And that it would have put the plaintiff in a very difficult position where they have effected service based on the affidavit of their process server, and they're getting a completely different story. And now the question is, what do you do?
So is that in the record that the Ms. Wright called a week after she or service was affected, or at least delivered to her home for her to hand over to her daughter?
Yes, it's in the printed case, not the standard record, but the printed case from the very first action, pages 38 through 39.
I have in my notes that there were
Thank you.
3 days left after the mother alerted you to the fact that her daughter didn't live with her, that there were 3 days left before the end of the continuance the court had given you.
I believe if you'll refer to 38, 39 of the record, you'll find that the court found that the service by Mr. Wright by Mr. Byers, the private investigator, upon Ms. Wright occurred 3 days before the deadline,
Well, in any event,
but not the mother's call, that was a week after that.
why was the default motion filed if you had information that this was a faulty service?
Because we also had information that it was a completed service. And in fact, we know that actual notice was accomplished because when we moved for default, we also served that on Ms. Camacho's mother in exactly the same way. And that very same day was when Ms. Camacho filed her motion to dismiss. In fact, I still believe that was satisfactory service because if you look to Christensen versus Capon, 139 Vermont 591, you'll see that this court found that a defendant waives their defense of lack of authority to accept service when they have actual notice and do nothing in response to a default judgment motion. Now, that issue wasn't raised below. We can't argue it here. We're not asking the court to decide it, but it's still relevant in response to that question.
But is it your position that service on the mother was good?
Our position is that the only question for this appeal is what was the reason for dismissal of the first action? And since the reason was a failure to properly serve the defendant, it falls within Section 558, and it need not be decided whether service was good there. It was an unappealed decision.
Oh, just one more then. So where's the default or neglect in 558A1?
Well, here's the issue. If the first court had dismissed because they said your time was up and you didn't seek an extension and there was no excusable neglect, we would have appealed. And the question of was the service actually effective would have been put to this court. But because the court found that the reason for dismissal was simply that service was upon the wrong person based on the representations of Ms. Wright, our view was that this fell within Section 558, and thus it was appropriate to refile, especially where the dismissal was not without prejudice, and that would ordinarily be the remedy if it wasn't in this posture.
Thank you. Sorry.
No,
I think I'm out of time.
Okay.
Thank you very much.
Thank you very much. So we'll hear from counsel for the appellee. Please come on up and, for the record, identify yourself and your.
Good afternoon, Your Honors. Kevin Lumpkin for appellee Victoria Camacho, and may it please the court. Before I begin, I want to answer two of your questions from the appellant's portion of the argument. At PC 72, Ms. Wright testified in the first action in the trial court that her phone call was placed 1 or 2 days later after being served, maybe 3. So if we have 3 days between when she was served and the service deadline, her testimony before the trial court was that it was in one of those 3 days that she made the phone call to appellant's counsel. Second, I heard a number of times appellant's counsel argue that there was some waiver below by my client to argue that service was ineffective. I heard appellant's counsel concede that that has not been briefed before this court, nor was it raised below. And so I would suggest that is irrelevant to your decision because it has been waived before you. This court should affirm the trial court's dismissal for 3 reasons. First, the plaintiff failed to serve Ms. Camacho within 60 days of filing her complaint, and she also failed to make a timely prospective motion to extend that deadline. By the time she filed a motion to extend the service deadline, it was beyond that deadline, and the trial court found on the record in the first case that there was no excusable neglect. That is as far as this court need go in analyzing this case. It does not need to touch Section 558A1 at all. If you do reach Section 558A1, by its plain terms, it applies to insufficiency of process, not service. Only service is at issue in this case, not process. And third, even if Section 558A1 does apply, it only applies in cases of unavoidable accident or default or neglect by the person to whom the process was committed. And I would submit that none of those things are the case here. As the trial court correctly found below, there were many opportunities to avoid the outcome. Appellant simply didn't take those opportunities. Let's start with the timing for service. This case was filed on June 21st of 2022. Under Rule 4, the appellant had 60 days to serve Ms. Camacho. The appellant did not serve Ms. Camacho, nor did she file a timely motion to prospectively extend that deadline within those 60 days.
Mr. Lumpkin, is your experience that those motions to extend service based on difficulty finding a defendant are generally granted?
If they're filed within the time, yes, it's always
filed
granted.
within that window.
And that's really the issue, and what Judge Tor spoke about in, I think, PC 129 in the trial transcript below. Why was there no motion within those first 60 days to simply extend the time? Usually, that doesn't matter, because you can dismiss and refile, you've got plenty of time on the statute. Here, by the time the trial court sorted out all of the issues, the statute had run, and this court held in Ferencia and many cases since then that where what would otherwise be a minor procedural error crosses with the statute of limitations, dismissal is mandated because this court requires strict compliance with procedural rules where they interact with the statute of limitations.
Mr. Lumpkin, any factual dispute whatsoever that the statute of limitations ran in April of 2023, 3 years after she was, the plaintiff was released from prison?
Not that I'm aware of. If there is a dispute, it's not before this court. So the 60 days runs on August 20th of 2022. And by that time, the plaintiff did not even put the case out for service. And that's important because of the Weisberg case, the only published case interpreting the modern Section 558A1 statute. In that case, this court avoided construing that statute because the plaintiff failed to put the case out for service within that first 60 days. So because it was impossible for the case to be served within those first 60 days, Section 558A1 does not come into it. Now, the appellant argues that because the state might have represented Ms. Camacho, she was not required to effect timely service or move to extend. But of course, the state may be representing Ms. Camacho also entertains the possibility that it might not. And so we would argue that it was incumbent upon plaintiff to either effect service or make a timely motion.
In other words, he failed to, he acted at his own peril by not doing one or the other.
Exactly right. And typically that's not a big issue, but as the trial court found below, the only time that the trial courts are deciding these issues is when they interact with the statute of limitations. But even if we accept that argument and we run the 60 days from when the state said we are not representing Ms. Camacho, there's still no service and still no prospective motion to extend the deadline. The first motion to extend the service deadline is filed 9 days after it ran, even with that generous start date. And the trial court found at PC 129 on the record in the first case that there is no excusable neglect justifying that 9-day late file motion to extend time. Under Ferencia and its progeny, we've cited 5 cases in our brief that stand for the proposition that where procedural rules are not followed and that crosses with the statute of limitations, dismissal is mandated. That happened in Ferencia. It also happened in Beebe versus Eisman, Kelty versus Davis, McClellan versus Haddock, Quinlan versus Five-Town Health Alliance, and Inrate von Turkovich. We would suggest that this is simply another in those line of cases, and Section 558A1 does not come into it. But if this court does interpret Section 558A1, its plain text says that it applies, quote, where the action is dismissed for insufficiency of process. As was pointed out earlier, insufficiency of process and insufficiency of service of process are 2 separate bases under Rule 12b to dismiss an action. Process is the documentation that accompanies a complaint, namely the summons, and service is the act of getting that summons to the defendant. Now, Attorney Valenti asked, well, how could it be the plaintiff or the officer who could commit a mistake in summons? Well, when we serve cases, sometimes we prepare the summons, And sometimes, especially in 1972, when the statute was enacted, the court hands us the summons. So my paralegal could hand me the wrong summons form, say the one that has 20 days to answer the complaint instead of 21, even though that was like 10 years ago. Some folks are still doing it. Or the court could do that. The judicial assistant could, especially with a pro se litigant, just pull from the wrong pile. As Attorney Valenti noted, even an incorrect county listed on the summons form might be a basis to say, hey, you should dismiss for insufficiency of process. This summons, this legal document is defective in some way because it's outdated, because it's wrong, and that is a basis to dismiss. I would.
Had your client been living at her mother's home in New Hampshire and not in Massachusetts, would the service have been appropriate? Would that be sufficient service of process at the date on which it was left at the home?
It would be sufficient service. It would not cure what I would characterize as the original sin in this case, which is that the deadline had already expired by the time service was accomplished. But if we roll back the clock and imagine that Ms. Camacho had effectively been served and she had in fact been living with her mother, this likely would have gone a different way because we would have made a motion to dismiss based on that untimeliness. And there would have been time to dismiss and
The
refile.
gap between the court order and then the secondary request for the extra 30 days.
Correct. But that motion would have been filed in January and the statute would not have run until April. And so most likely the plaintiff would have dismissed and refiled and gotten a second chance at the statute of limitations. This is what in other circumstances might be a minor procedural error. But in all of these cases under Ferencia, that is always the case. In fact, in BB versus Eisman, the issue was that the plaintiff had a piece of paper where the defendant had accepted service and just failed to file it. And by the time he did file it, this case had been dismissed for failure to prosecute and the statute had run.
Am I remembering this correctly? Wasn't service of process that language in 558 and then it was taken out?
It was, as we know from Tracy versus Grand Trunk Railway in 1904, when that case was decided, the phrase was sufficient service. At some point between 1904 and 1972, the legislature changed the language from sufficient service to insufficiency of process. And this court generally assumes that when the legislature does something like that, it does so advisedly. And it also assumes that the legislature means what it says.
So what is insufficiency of process then?
Insufficiency of process is the wrong summons. It's a little used portion of Rule 12b. In fact, we quote a section from Wright and Miller in our brief explaining the difference because often they are conflated, but they are two different bases. Insufficiency of process was more prominent when courts had a bigger role in preparing the summons documentation. Now it's a little bit less controversial and a little bit more rote to prepare that summons. But perhaps in 1972, when the court was handing all litigants the summons paperwork, surely there were errors from time to time in that summons. And if you, a defendant, received a summons that was incorrect in some way because it had been prepared by the court officer, and that court officer had neglected his or her duty in some way, gave you the wrong one, that would be I think it's a 12b4 motion for insufficiency of process. Service was great. The service got on the person, no problem, but the documentation, the summons was wrong.
So
that is the difference between service and, go ahead.
it refers, Mr. Lumpkin, then to the contents. Is that right? The
Correct.
contents of the summons.
Contents of the summons, you're exactly right, Justice Waples. Even if this court reads service to mean process, and even if it looks beyond the failure to serve within the first 60 days and the failure to serve within the second 60 days, even with a more generous start time, there was still no unavoidable accident, as the trial court correctly found below. That's both because of the failure to timely serve under Rule 4 and because of the phone call. So the fundamental question the appellant is asking you in this case is, we entrusted process to a process server to go to the appellant's last known address and affect service. And he said he did that. So how are we appellants to know that she didn't live there. But the record provides an answer to that question. Ms. Wright, my client's mother, called plaintiff's counsel's office to say, my daughter doesn't live with me, you've served the wrong person. At that point, the plaintiff had an opportunity to avoid the outcome. She could have moved for service by publication. Can't find this person, we need to serve by publication. She could have moved for a TAC order or otherwise raised directly the issue of, is service on the mom good enough? I need you to hold a hearing. Instead, she chose not to do those things. She filed a motion for default judgment premised on the notion that service was valid and that the appellee, then defendant, failed to answer the complaint. But all the while, the appellant had noticed that this was a contested issue. And once again, I go back to this, this concept of do this at your own peril. This was another opportunity for the appellant to avoid the outcome that for whatever reason she did not take. Even if you read section 558A1 to apply to service of process, this was not an unavoidable accident. And even with the generosity of a remedial statute, we can't change the words of the statute. It says unavoidable accident due to a failure of process. And this was not an unavoidable accident, and it did not have to do with process.
Mr. Lumpkin, are you aware of any, there was an issue we haven't had any discussions about, that's the equitable tolling?
Yes.
Any cases that you're aware that we recognize certain situations where there could be like a fundamental fairness determination on why service was not made?
Yes, I would say there's one case that is primarily at issue here, and that's BB versus Eisman 2012 VT 40, which holds that where the appellant's own, quote, admissions or inadvertences contributed to the problem, equitable tolling is unavailable. And so because of the same reasons I've listed, the failure to serve within 60 days and the failure to act on that phone call, under BB, the appellant's own admissions or advertences contributed to the problem, and therefore equitable tolling is unavailable.
Mr. Lumpkin, does equitable tolling apply if mom is not acting as the agent?
That's the other point I wanted to make. The equitable tolling requires some active misleading or interference on the part of the appellee. There is no evidence in the record that Ms. Wright was acting on Ms. Camacho's behalf. The trial court essentially found that Ms. Wright, I see my light is on.
You finish your answer.
The trial court essentially found that Ms. Wright was shading the truth to protect her daughter. There's evidence of that. There is no evidence that the daughter was acting through her mother or that they had an agency relationship.
Okay. Thank you very much. Does the appellant have any time?
Appellant